So as Professor Mystic said in the last video, all crimes are defined in statutes. This wasn't always the case. Prior to the late 1800s, there were still some state crimes that were defined entirely by judicial decisions that had come over from England when the judges there had first defined crimes. But now in the modern 21st century, all statutes, all crimes are defined by statute. And as Professor Mystic said in that video, that leads us to questions of interpretation. How do you go about defining these statutes? So I want to lay out for you two primary schemes that state statutes for crimes have been broken into. So by and large, there are two camps of criminal statutes. Those that are derived from the common law definition of crimes. Basically, when we started to put these crimes into statutes, the codifier simply put into the statutes those things which had been carried over from England from the judicial interpretations of crimes. And then in the 1960s, a new way of understanding crime was created by the drafters of the Model Penal Code. Now, largely, the Model Penal Code was the product of a bunch of law professors in the 1960s that initially didn't catch on and never fully caught on. But virtually every state will have some provision that incorporates this new Model Penal Code. We will note for you when we're going through the crimes when a statute is taking the common law approach or the Model Penal Code approach. It won't be often that we'll note this, but what you will find is there are certain crimes like attempt in which the drafters of the Model Penal Code took a very different view than the common law had taken. For instance, the drafters of the Model Penal Code wanted punishment for attempt to be more readily had. The drafters of the Model Penal Code wanted to be able to punish people who had come not so terribly close to completing the crime, but had clearly evinced their desire to do harm to society. They wanted to prevent crime and be able to punish attempts at crime well before they happened. Whereas the common law had much more of a focus on harm. The Model Penal Code would have a much greater, the common law would have a much greater difference between an attempt and a completed crime in terms of the way it's punished. At one point, the common law actually didn't punish attempted murder at all, and then later it came to. But the idea being that the common law, the inherited law from England, was really something about punishing harms done to society, whereas the Model Penal Code came to be about punishing the desire to commit a crime that would harm society. And so as we come to interpret statutes, we'll look at the language of the statute. And one of the questions we're going to ask is, where did this language come from? Did it come from the language of the common law, or did it come from the Model Penal Code? And from these various sources, we will draw inferences about what was in the mind of the drafters and what was in the mind of the state legislature when it chose to make this a part of the law. So that's one step in interpreting a statute. Where did the legislature get this language from? And what was the philosophical perspective of the people who wrote that language?